Please help. Can my sister evict me? We had a viewer from Michigan ask whether or not her sister could evict her from a house she inherited from her mother. Her sister is the executor and somehow put her name on the deed. Let's get into some of these details. I'm 𝗪𝗵𝗻𝗂𝗍𝗍 Law, an estate planning attorney in New York and New Jersey, and we provide peace of mind to families through our high client value services. If you are seeking assistance in either estate planning or for the administration after the loss of a loved one, we can help. You can reach us at 𝗫𝗺planningattorney.com for a free consultation. And speaking of value, we are here to educate everyone on a regular basis. So please ask questions and share so together we can help some folks along the way. Now, first of all, full disclosure, I am not licensed in Michigan, so you need to speak with a Michigan counsel because I don't know the laws there, and I can only give you some general insight. Now, how you inherited the house is extremely important to understand on what your rights may be here. If it was under an estate plan and it said house to you, your sister's name shouldn't be on the deed and something funky happened. If your mom told you you're getting the house and her estate plan says equally to you and your sister, different story. If your mom added you to the deed and your sister somehow took you off, again, different story. We have to know all of those details to really give insight. But it is important to note that an executor can't just necessarily take someone off or kick somebody out who has a legal right to be there or has certainly legal ownership via inheritance, if that is the case. So your sibling, your sister, can't just kick you out until we have some sort of basis as to who the owner is. I did do a video about when multiple parties, siblings, will own real property and what happens when one wants to sell and another doesn't, especially when someone's living in the home. And that can get to be a little bit of a hairy circumstance. But the executor can't just personally claim ownership of the assets. That's not how that works, especially if there is a will or a trust plan or something that says another party is at least partial owner of it. Now, if she did have court approval of making those transitions, that is also a different story. So you have to look into how this happened and why, and what your legal rights are. Now, just to play devil's advocate and say you were not the sole owner or sole beneficiary of the home, and let's say it was supposed to go to both you and your sister. You're paying of the bills. So this viewer said she was paying the mortgage and the bills because she's living there. It will help in a settlement discussion that you have been doing so. But the likelihood is that your sister would also say, well, that goes towards whatever rent you'd be paying for having lived there. So just know that that's often a discussion in these circumstances if it's supposed to be shared ownership. Now, because probate and property laws and deed transfers, all this stuff is different and can have varying contexts within each state, please, please, please reach out to a probate real estate attorney, something like that in your area, so that you can review the circumstances, get a better understanding, and know what your rights are. You may need to hire what's called an estate litigation counsel. Our firm does not handle it, so it's not necessarily just an estate planning attorney or a probate trust administration attorney. You do specifically may need an estate litigation representation. Again, 𝗪𝗵𝗻𝗂𝗍 Law. We're an estate planning practice in New York and New Jersey, and we provide peace of mind to families through our high client value services. If you do need our help, you can reach us at 𝗫𝗺planningattorney.com for a free consult. We hope you've learned something new here today. Please don't forget, share, 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 and take care. Bye-bye.